Well, good afternoon. We ready to start up again? Yeah. So we're going to be working with character evidence and 404B evidence, which is not really character evidence, but some people say it is. How many of you have difficulty with character evidence? I do. I mean, I think it's complex, the way the rules interrelate to each other when you're dealing with 404 and 607 and 608. And, it can be a little unnerving. So what part of this hearing don't you understand? The part after all rise. That's pretty much the way I felt about character evidence for a long time. Still learning about it, of course. So what I did is I tried to figure out some way that I could analyze a character evidence issue and have it point me to kind of the right rules and how it can be offered and how cross-examination can occur with regard to it. So the first thing I do is I ask myself, is it character evidence? And if I say yes, then I ask myself, okay, how is it being offered? Is it being offered circumstantially, directly, or for some other purpose? And if it's being offered circumstantially, and when I say circumstantially, it's really being offered for propensity. Because the person acted this way in the past, they probably did the same thing on the time period that we're talking about. So that's circumstantial evidence. And if it is being offered circumstantially, it can only be offered as opinion or reputation evidence, and you can cross-examine on specific instances of conduct when a good faith belief, when you have a good faith belief as the existence of those specific instances of conduct. Now, if it's being offered directly to show character when character is an issue in the case or the issue in the case, you can offer it either as specific instances of conduct or through opinion or reputation evidence. But the type of cases where character is a direct issue in the case are few and far between. So defamation cases, negligent entrustment cases, the death penalty phase of a death penalty case, because their character is the issue and the only issue really, child custody cases arguably, and maybe entrapment. And you're guided by Rule 405B in admitting the evidence there. Or if it's being offered for some other purpose, such as typically credibility. So 607 is bias, interest, motive. Specific instances are admissible. Or 608, character for truthfulness. Opinion and reputation evidence is admissible. Cross-examine on specific instances of conduct under 608B. If it's being offered through impeachment under 1390-101, prior felony convictions, or it's attacking the witness's ability to observe the actual incident, remember it, and then recount it currently, or impeachment by contradiction, we'll talk about that, has to be a non-collateral manner, or it's being offered for another purpose like plan, scheme, motive, design, other transactions, or res gestae evidence, something that is inextricably intertwined with the incident that a person's on trial for. So what we're going to do is we're going to take a look at various character evidence issues and try and use this format in analyzing how a answer should be obtained. So Fred Felon is who we're working with today, and Fred's charged with second-degree assault and punching his girlfriend Nancy Nice and breaking her jaw. According to Nancy, this assault occurred at their residence on November 30th, 2015, when both were drinking, and for some unknown reason, Fred got mad. Okay, that's our factual scenario. There's Fred, the way he looked before and the way he's at trial. Just another pretrial makeover. So Fred can offer evidence that he has never been arrested before this incident. True or false? With Allison's assistance, you see we have the counter. How many folks do we have? About 20, 21 or 2? About that? 23? Good. Okay. So let's talk about what Fred is doing here. Fred is offering evidence that he has never been arrested before. And what is the purpose of him offering this evidence? Bolster his credibility. What he's saying is that the fact that I've never been arrested before means that I am a law-abiding citizen and I wouldn't have done this incident. I wouldn't have assaulted my girlfriend, right? Okay. So it's being offered circumstantially, right? To show propensity. Because I've been a good person in the past, I must have been a good person on this day in question, right? Well, if it's being offered circumstantially, the rule is you can only offer it as opinion or reputation evidence. Is this opinion or reputation evidence? I've never been arrested before? Absolutely not. Need to put somebody on the stand that says that Fred, I've known Fred for a long period of time. I've talked to a lot of people, and it is my opinion, and his reputation is that he's a law-abiding citizen, right? That's how it has to be offered. And that if it is offered that way, then you can cross-examine on specific instances of conduct under Rule 405A, right? Defendant's lack of criminal record, not proper character evidence, because it's not opinion or reputation evidence, being law-abiding. Case right on point. Gallegos. So what are the pertinent character traits? We just talked about one. Being law-abiding, right? That's one. Honesty or truthfulness, right? Okay. What? Peacefulness, yes. Some people say temperance, okay? If you're in the military, good military character, but that's about it, right? That's about it. So peacefulness, law-abiding, honesty, truthfulness, temperance, okay? Good military character if you're in the military, okay? What about being sexually aggressive or being non-sexually violent? Yeah. Colorado case, People versus Nardine, 2016 case said sexual predator is an improper character trait. There's an older case from the Court of Appeals called Knowles versus Board of Education, non-sexually abusive character trait. They said that that was a character trait. I don't happen to agree with that case. There's a really good analysis of the whole idea of whether sexual abusiveness or sexual aggressiveness is a character trait. I don't think it's a character trait. I think it's a behavior, not have anything to do with character. And State versus Parkinson does a great job of analyzing that particular issue. But don't be surprised if you might get Knowles cited to you at some point in time. It's clearly the outlier in the case law in Colorado, by far, or nationally. So, after Fred offers the reputation testimony that he is law-abiding, the prosecutor can ask about prior arrests for DUI and drug possession. True or false? Had 23. It's always a bad sign for the speaker when the numbers start going down, right? Particularly when people are still in the room. That's when it's really bad. Okay, 23. Good. Whoa, 96 and 4%. Okay, so if somebody offers testimony that they have talked to a lot of people and known Fred for a long period of time and his reputation in the community is being law-abiding, then in the discretion of the court, you can ask questions under 405A as to behavior that would contradict that. So either conduct or arrest, that type of thing. Okay. On cross-examination, inquiry is allowable into relevant specific instances of conduct under 405A. So typically, the way you ask these questions is developed in a case called Michelson versus United States, which even predates the federal rules. If it is reputation evidence that's being given, the way to frame the question is, have you heard that Fred was arrested for DUI and drug possession? Okay. And if it's opinion evidence, you know, I've known Fred for 17 years. We go to church together. We carpool. Our families spend weekends together out at the lake. And I have an opinion with regard to his being law-abiding, and he's a law-abiding person, right? That's the individual opinion. You have to have a good faith basis to ask the question. So one of the questions on the checklist that I first gave you is, are there going to be any character witnesses in this trial? And number two is there going to be some issue about cross-examining those? Because I want to know that there is a good faith basis to ask the question. So these are actual excerpts from Royal Navy and Marine officer fitness reports. Probably not proper character evidence, but they are kind of funny. He would be out of his depth in a car park puddle. Since my last report, he has reached rock bottom and started to dig. She sets low personal standards and then consistently fails to achieve them. And then the last one is the one I love. Works well when under constant supervision and cornered like a rat in a trap. Yeah, well. Reputation witness has not heard of the DUI and drug arrest, so the prosecutor can offer certified records of the convictions. True or false? Now these are misdemeanors, clearly the DUI. And they're, so 21, going. All right. So why do you think that the prosecutor shouldn't be able to offer these records of the convictions? They're not felonies, number one. Okay. So what did your witness do? Your witness got on the stand and said, I've talked to neighbors, I've talked to people at the church, I've talked to people at work, and Fred's reputation in the community is that he's law-abiding, right? Well, the fact that he doesn't know anything about these convictions, what does that really tell you about the opinion? Okay? And if he did know about the convictions, then, or even the arrest, say, he had heard about the arrest, well, what does that tell you about the opinion? So the rule is we're not going to let the sideshow take over the circus. So you're bound by the witness's answer. That's it. It's over. Because the answer itself says all that needs to be said. Which is very interesting in the sense if you don't know about it, you make an inference about how well the person knew, right? You make an inference. How well did they really know Fred? Even though there's no evidence that they in fact had a DUI or were arrested for drug possession. So the people that know how to work character evidence well, they have some formal looking document, usually with a blue back on it, and has some big seal on it that somehow, and they say, have you heard that Fred was arrested for DUI 7 months ago, right? And so it makes it appear that it's coming off something that's truly official when, who knows? That's why the court gets to act as a gatekeeper. Has to be a good faith basis. Good faith basis, what is that? Rap sheet? That'd be good. Okay. And in the discretion of the court can say, no, not gonna let you do it. It's 20 years ago. Doesn't have anything to do with this case. Federally, I've seen cases where they permitted convictions for assault with a deadly weapon, menacing, child sexual assault, DUI, and harassment. All of it, those questions were permitted. In the federal cases, I have seen where the court has permitted questioning about rumors. Because if you're talking about reputation, rumors can be important. But you can keep that out. I'm just saying that there are cases that have proved that. Must accept the witness's answer, no extrinsic evidence. Don't want the sideshow to take over the circus. In prosecution's case in chief, the DA can offer reputation evidence that Fred is a violent man, true or false. So if you want to take a look at the rule, you want to be guided by 404. '20, 21, 23. 87% of you say false. Yes, the general rule is the defendant has to start the ball rolling. So in a criminal case, evidence of pertinent character trait offered by the accused or the prosecution to rebut same. So the prosecution out of the box can't offer character evidence until the defendant gets it rolling. So Fred's assault case, as part of the defendant's case, Fred testifies, in his opinion, Nancy is violent. This is permissible. True or false? $21. 23. So before Fred does this, there has to be some foundation laid on how well he knows Nancy, and that he would be in a position to form an opinion. There has to be some basis for the opinion that she is violent, and it is true that he can do that. Pertinent character of victim is admissible by the defendant. So next question. Prosecution's rebuttal case, the DA offers opinion evidence that Nancy is peaceful and that Fred felon is violent. This is permissible. Okay. 83% say yes. So the defendant has gotten the ball rolling because he just testified that Nancy is violent, right? And his opinion is Nancy is violent. And under Rule 404, you're now allowed to offer similar character traits of the defendant and then rebut what the defendant put on with regard to Nancy's character. So he gets to do both. Number one, the prosecutor or she gets to say through opinion or reputation evidence that Nancy's peaceable and Fred is violent. But once again, how are we offering? Is it character evidence? Sure, right? Peacefulness, we agreed on that. How's it being offered? It's being offered circumstantially, and in circumstantial offer of character evidence has to be done through opinion or reputation evidence. We're doing it through opinion evidence. There's a case, and I don't know if it's in one of the materials I gave you. The foundational requirements are under a case called Lombardi versus Graham on what is necessary. So when defendant offers evidence that the victim is violent, aggressive, prosecution can offer the same character trait of the defendant. So in defendant's case, Freddie's friend, Alan Alibi, testifies that he saw Nancy beat up a bouncer in a bar fight 2 weeks before the charged assault. He told Fred about it after he learned of the charges were filed against Fred. Fred's testimony about what Alan told him is admissible. True or false? Whoops, let me see if I don't see our little thing up there. Yeah, there we go. Fred learns after the assault of Nancy that Nancy beat up bouncer 2 weeks before the charged assault. Admissible. So there's two evidentiary issues here, right? 20. $21. $22. Somebody's filling out their application for a appellate judgeship? 23. Okay. So let's talk about it. First of all, is this character evidence? Yeah, sure. I mean, it goes to whether Nancy is a violent or peaceful person, okay? Is it being offered circumstantially to show that Nancy acted in conformance on the day that Fred's charged with the assault? Yeah. Is it being offered through opinion or reputation evidence? No. Not admissible. Okay? So what is the other issue? There's relevance, okay? And isn't there a hearsay issue here too? Yeah, okay. But the hearsay issue kind of dovetails, it arguably would be notice to Fred that Nancy's violent, but when did he learn it? Afterwards. So, on the relevance, it's not relevant. So that's how you analyze those issues. Okay. Talked about this. Okay, so what if Fred knew of the assault at the time that he had the altercation with Nancy? What if his friend had told him before the assault that Fred's charged with, you know, I was at this bar about a month ago, and these guys were wising off with Nancy, and she hauled off and decked both of them. Okay, he knows that. Do you think it's admissible? Well, is it character evidence? That she's violent? Sure, it's character evidence, right? Is it being offered circumstantially to show that she acted in conformance therewith on the day that he punched her? Yep. Is it being offered through opinion or reputation evidence? No. So it can't come in that way. Is it being offered directly to show character when character is the issue in the case? This is not one of those cases. It's not a negligent entrustment or defamation, death penalty phase, a death penalty case, child custody case, that type of thing. So it's being offered for some other purpose. What is the other purpose?
About self-defense.
Right. The reasonableness of his actions in the degree of force that he used. Okay? So it's being offered for some purpose altogether different. And so, People versus Jones, Ibarra, etc. Specific acts of violence, victim, not admissible where defendant not aware of saying, but opinion and reputation evidence is admissible if self-defense is an issue. But also, evidence that defendant knew before charged assault that victim involved in prior assaults admissible, not as character evidence of victim, but to show the reasonableness of the force that the defendant used in the time in question. hey, she beat up these other guys, I was just defending myself and I had to hit her 3 times. Members of the jury, does my client look like a man of violence? Okay. So in Fred's assault case, the defense offers through its first witness, Alan Alibi, testimony that in his opinion, Fred is truthful. The testimony is admissible. $23, going. $22, $23, going for 23. Nope. There we go. So what rule are we guided by here?
Is it a relevance thing? Because it's not really necessarily a pertinent creating an assault.
Well, that he could be a relevance issue, depending upon what the issues are in the case. But assuming that it's relevant for a minute, what do the rules tell us about evidence of truthful character? So we're guided by Rule 608A. And when can you offer evidence of truthful character? After the person's character for truthfulness has been attacked by opinion or reputation, evidence, or otherwise. Okay? We don't know that that's occurred at this point in time. Right? It's one of my favorite cartoons. If I've got to tell the whole truth, nothing but the truth, what sort of fair trial is this going to be anyway, right? So, next question. Prosecution asked Fred on cross-examination, so if Nancy said that she was afraid of you, she would be lying. The statement is admissible. True or false? $19, $20, $23. So, what is the prosecution really doing here? They're asking the witness to give an opinion with regard to somebody's credibility on a specific date and time. Is that ever permitted? Never, ever, with a couple of kind of exceptions. So nothing's never ever. So, and the general rule is a witness may not give an opinion with regard to a person's truthful character on a particular time. Venalonzo, I think, Justice Boatwright, you wrote Venalonzo, didn't you? Okay. Read Venalonzo. It is really a good analysis of this issue, but you should read Venalonzo for another reason, because it sets out the new rule for determining what is expert testimony and what is lay opinion testimony. Improper bolstering included comparing to other sex assault victims, forensic interviews led to dropping charges in other cases, no signs the child was lying, child's not sophisticated enough to make up that type of story, child had no reason to accuse the defendant unless it occurred. All of these are improper bolstering, and what they're really doing is saying that the child was truthful on that character. But what happens is we see it in a very kind of concealed way. Well, did Nancy seem sincere when she was, sincere equals telling the truth, right? If you're going to get reversed, these are the areas that you're going to get reversed on, because they're close issues of credibility, and the testimony, particularly when it comes from an expert, we worry that the jury is going to give that added weight. So I was giving a presentation in another state, and I made the statement that a witness can never say can never, say another person is being truthful on a particular occasion. Person raised their hand in the back. Judge, I'm from New Mexico. I go, okay, I'm at the National Judicial College. I'm teaching the federal rules. That's not the rule we have in New Mexico. Really? Yeah. Do you know New Mexico is the only state in the country that permits polygraph exams? Yep, admissible to this day. So there are, so I talked about short earlier. There are nuances in this rule. So expert may testify the typical demeanor and behavior traits displayed by a sexually abused child because it assists the jury in understanding the victim's behavior. Reactions of children have been subjected to sexual abuse that might in other circumstances be considered bizarre. Because it's not being offered for the truth, showing that the child is credible, but rather to explain why these unusual behaviors are coming out of this child. Okay. So there are other exceptions as well. Usually when the defense opens the door in some way, like attacking the police investigation, or the Heredia Cobos case, where the defense opened the door and then the court said it was proper to allow the testimony that the child had not been coached. Okay. So on cross-examination, defense counsel asked Nancy's friend Sherry, who testified about Nancy's injuries, whether Sherry was arrested for false information 3 months ago. This is permissible. 23, so almost an even split. So what rule are we dealing with? 608B, which says that in the discretion of the court, inquiry may be made on specific instances of truthfulness or untruthfulness, right? So is an arrest a specific instance of truthfulness or untruthfulness? Trick question, sorry. It's the conduct, not the arrest. So if the court's going to permit the question should be, isn't it true that you gave a false name to a police officer on June 30th, 2018? Okay? It's the conduct that is the proper area of inquiry. You have to have a good faith basis to ask the question. So, what is an act of untruthfulness? Is using a false social security number an act of untruthfulness? Yes. Is passing bad checks untruthful testimony or untruthful behavior? Yes. Okay. Is shoplifting untruthful behavior? Yep. All are untruthful behavior in proper areas of inquiry under 608B in the discretion of the court. So, People versus Segovia, Campos, tax return. Now, you under 403 can exclude this, but here, the court permitted passing bad checks 20 years ago. With women, I never try and sugarcoat the truth. What about all those whoppers you tell your girlfriends? Those are lies. They're an entirely different matter, right? Fred denies any false information incident, and defense counsel wants to call the police officer to whom the friend gave the false name. This is permissible. We're going to finish way early. Is that a good thing? "24." Somebody either woke up. Oh, okay. So, most of you said it's not permissible. Why is it not permissible? Yeah, I mean, it goes, did two, did not, did two, did not, right? The sideshow takes off with the circus again. But what if it's something that's, really, really goes to the heart of the matter? You're generally stuck with the witness's answer unless, always an exception to the rule, of course, unless it is a non-collateral matter, okay? Maybe it's something about false information in the investigation of this case. Maybe it's something that it's the defendant that's on the stand, and it's close in time and false statement that the defendant gave. So generally, you're bound by the answer, no extrinsic evidence but if it's impeachment by contradiction on a non-collateral matter. And the case you want to read on this area, in this area is People versus Hall.